Is there a maximum number of documents you can request?
The law doesn't really say that there is a request limit for production of documents.
Hi, everyone, and thank you for joining us again. I'm attorney Holly Mullin. I'm the managing partner at Sterling Law Offices, and I have with me today attorney Robert Keenan. Rob is a partner at our firm. He's an excellent litigator, and that's why I have brought him on today to talk about different types of discovery and when we use them in a case. Thank you very much for being with us today, Rob. How are you doing?
I'm doing great. Thank you for having me.
Absolutely. So let's dive right into this. So, when talking discovery, you had met with us on an earlier episode talking about the difference between sort of an informal disclosure of information versus formalized discovery, where we are making demands of specific records or information that the other party is making under oath and under a designated timeline. So I want to dig into more detail about different types of discovery. It doesn't all look the same. It's not all used for the same types of case. We don't gather that information in the same way. So knowing the right discovery tool can make or break your case. So let's talk about give me the different types of discovery that you use in your cases.
Sure. So I'd say there are the four main types of discovery, and I'll kind of order them in the most common use. And that would be request for production of documents, interrogatories, request for admissions, and then what we call depositions.
Okay, helpful. So top four, there may be others, but in family court, this is what we're seeing most frequently and essentially in that order of use. So let's break each one of those down even a bit further now. You mentioned request for production of documents. Tell me more about that.
So that's essentially exactly as it sounds. We're requesting the other side to provide us with specific documentation. A lot of times, the documents that we're requesting are more aligned with financials. So, bank statements, credit card statements, 401k statements, W 2s, business records, basically documentation to help support the disclosures made by the party with respect to their finances.
Excellent. And what's the timeline? Okay, you serve a person a discovery request for production of documents. When should you be able to expect to get responses on those?
Yeah, great question. And that's usually the first question I get from my clients is like, hey, Rob, you just asked my spouse to produce all this information. When do they have to get it to us? Well, the law says here in Wisconsin that they have 30 days to produce it from the time that information or that request is served upon them. So 30 days.
Okay. And is there a maximum number of documents you can request?
So another really good question. So in the law doesn't really say that there is a request limit for production of documents. So, reading the plain language of the law, you should be able to send out as much as you want. However, we all understand that the law in family court is involved with people, and so there are times where people might be saying, "Hey, this is a lot of information here. Let's tone it back a little bit." So, we usually what we do is we don't flood a bunch of information at one request. If we need to, we'll break them up, because a lot of times what we want to do is we want to get the right information, the necessary information. So even though there isn't necessarily a limit, we do want to act within reasonableness when making these requests.
That makes sense. Yep. And then you mentioned, I think, in second in line was interrogatories. Tell me more about that.
Yeah, so this is a fun word. Interrogatories is basically where we're just asking the other side questions to answer for us. They can be in the affirmative questions, or they can be simply ones that maybe you have to dive deeper into. Like, hey, did you travel out of country within the last 5 years? And if so, where did you go? Kind of thing. So with interrogatories, you're basically just asking the other side to answer questions that you have. Usually these are tied into the production of documents that you're also requesting. So for example, it's Hey, you listed one W-2. Did you only work one job last year? Right. So we can kind of try to line up what they're producing with what their answers are with respect to that particular issue. Unlike, I'm sorry, unlike production of documents, though, interrogatories, there is a hard line cap on what you can request. You are only allowed to ask 25 questions or 25 interrogatories, so to speak, and that does include their subparts. So, for example, if I was to say, please provide me with the names of all the bank institutions that you have an account with. Please also include the account number, the name of the bank, the balance. All those extra questions are considered subparts. So that would not just be one question, it would be 4 or 5. So we take that into consideration as well when making our requests.
Great point. So, I mean, you don't want to just ask fluff questions. You got to get to the point, ask what you need to ask so you don't run out of your 25
Exactly.
total.
Exactly.
Okay, I think next on your list was requests for admission. Tell me about those.
Yeah, so these, and maybe fun's not the right word, but I sometimes find these to be fun to use, though they are used rarely. But this is essentially where you're trying to get the other side to admit or deny a specific fact. These, though, you want to be very strategic with, because generally, like, you want to kind of already know what the answer is before you get them to respond. It helps you make sure that you're not blindsided by things, that you have all the facts, because these are answered under oath. So when they respond to these admissions, they are doing so under oath, and that helps with establishing the credibility or lack of credibility of the responder here. Again, they also have to be able to produce these within 30 days.
Understood. And so it sounds like requests for admissions. I mean, if you're using those, you're locking them into a statement so that they can't later deny it. If they've admitted it in their request for admissions, you can use that essentially as a statement of fact to the court. It's undisputed. They've acknowledged it. I mean, is that a fair description?
That's a great way of describing it. We work with facts. That's what the court has to rely on when determining outcomes. And so, if we're able to streamline that process and provide the court with undisputed facts, for example, were you on Main Street at 5 p.m. on Saturday, August 15th? And they answer yes or no. If they answer yes, and that's good. We have a direct fact that we no longer have to worry about being disputed. So it helps streamline the process. It makes the court's jobs a bit easier when making decisions, and it also helps with negotiations as well. When there are no disputed facts and we're just focusing on resolving the case, it makes things a lot easier.
Perfect. And then I think our last one that you referenced of the top 4 was deposition. Can you describe what a deposition is? We've all heard that word, right? Maybe we haven't heard of interrogatories and requests for admissions, but we've all heard of a deposition. So paint a picture. What does that actually entail?
Sure. So a deposition is essentially kind of like what you see on TV when you're watching a trial where somebody is on the stand and they're testifying in front of a court reporter and in front of the court. Now, the only difference is that the judge isn't there. There's no jury there. It's just the lawyer, the witness, a court reporter, and then the witness's lawyer if they have one. But
sorry to interrupt. It's like a closed door. Sorry, let's back that up so I'm not interrupting or speaking over. So it's basically a closed door interview. Is that, I mean, it's like they're sworn under oath. Is that how that works?
Yep, they are. So they are sworn under oath. And you're right, it's a closed interview. They are answering the questions provided by the lawyer, and they have to answer so truthfully. This essentially allows for evaluating credibility of the witness. It also kind of helps give us insight on what is to be stated at a trial, or if they get to trial and they say something different, you can always look back to the deposition and be like, well, hey, when we asked you this under oath the first time, this is what you said. It can therefore create issue with credibility. And as you can imagine, it locks the witnesses into their answers. So there are no surprises in the courtroom. I know we all like to watch the law shows, and when the witness says something and everybody gasps, right, because it was such a big surprise. That doesn't really happen in real life trials. Most of the time, if not all the time, the answer that's given is an answer that the attorneys knew was coming. And that's in large part because that witness has likely been deposed prior to.
Right. I mean, when good lawyering is involved, frankly, we don't want the surprises in the courtroom. We don't want the gasps and the Matlock moment. Like
Right.
our whole point is to avoid the trial in the first place, let alone get to trial to be shocked by something a witness says, right?
Exactly. Yeah.
So
Exactly.
when when are you using discovery? Is this in every single case situation?
It's not in every single case situation. It's usually only needed when we're getting maybe some pushback from the other side in cooperation. Now, with a divorce, as I'm sure many people understand, a divorce is a dissolution of a marriage, a dissolution of a partnership. And so when you are dissolving a partnership, whether it's a marriage or whether it's a business, there's information that needs to be exchanged between the parties. Just like anything else, you want to make sure you have all the information necessary to make a well informed decision on how to best effectuate this dissolution. And so we utilize discovery to get all the information needed, but most of the time people produce it voluntarily. So the need isn't always there. And sometimes, though, you might have complete cooperation, but the case is complex. Maybe there's multiple businesses or real estate and business entities that own real estate or inherited property that may have been mixed in with the marital property. And so we just need to make sure we get all that information so we understand exactly what we're working with here when we do get to the negotiation table.
Got it. Okay. So it sounds like you're sort of using the discovery on a case by case basis. You may not use it at all, right? It sounds like if you can be cooperative and you have source documents supporting financial disclosures, you may not need it. You may not need that formal discovery, but in other cases it's depending on the issues and procedural posture, meaning where the case is within its, is it heading to trial? Is it more likely to settle? That's sort of gauging what you feel like you'll need for discovery. Is that a fair statement?
Yes, it is. And the great thing about discovery is that it is not a one size fit all approach. One case I might need to send out requests for production of documents. Other cases I may not. Some cases I might need to get admissions. Other cases I may not. It's how you utilize it in the case that's what matters the most. And what I find discovery does is it really helps us uncover the things that we don't know that we don't know, right? A great example for this is I had a case wherein we conducted discovery and we learned that the other party was routing money from an individual account to an account that was held in their name along with their parents' name. That account was not disclosed on their financial disclosure statement. And the reason wasn't anything nefarious. It was just that they didn't think that they needed to include it because it was an account that they didn't own exclusively, that they owned with a third party not involved in this divorce. Had we not conducted our discovery response and saw that that money was moving from one account to the other, we never would have known about that account. And we never would have been able to factor in the balances of that account for the purposes of the marital division here. So a lot of times it can help us, again, kind of uncover those things that we don't know, we didn't even know we didn't know.
That's a great example. Thank you for sharing that. It's great to hear it in a practical context of how it's been used and how it was helpful to a client. I mean, it really just sounds like choosing the right discovery method really depends on what the needs of the client and the case are. And, it's like we think of depositions, they can uncover inconsistencies. Interrogatories can help you gather this factual background, and request for production of documents allows you to verify source information. So beyond just using the right method, it's the timing of the case, when it's needed and how it's needed. So using that discovery strategically can provide the clarity to both the attorney and the client, prevent surprises, and really put the client in a stronger position for negotiation or trial if it comes to that. So thank you for providing all of this information and breaking down the discovery process and all of the different tools in your toolbox. Always a pleasure to have you, Rob.
Yeah, thank you for having me.
4 discovery tools can expose what your spouse is hiding, but there's one asset most Wisconsin couples miss that changes everything. And by the time they find it, it's usually too late. So see what catches divorcing couples off guard in our next video.